Good morning, Mr. Baylor.
Good morning. May it please the Court, Jeffrey Baylor for Timothy Braley. This case arises out of the shooting death of Benjamin Sharon in Brockton in 1989. Mr. Braley wasn't charged in this case until 2000. First off, we contend that the trial court erred in allowing evidence in several instances. First, relating to a statement of co-defendant Glenn Aylward in the kitchen on the night of the alleged incident.
Did Mr. Aylward testify at trial?
No.
Okay.
The case was severed early on, and he was tried separately, and he did not testify at trial.
Okay. Was there evidence of a crowd? It seems to me your brief kept saying that the defendant shot into a crowd, but all I could tell from, I haven't read the transcript obviously yet, but all I could tell from the briefs was that there was Jones and the victim.
Well,
Yeah, and it occurred at 2 in the morning, didn't it?
I didn't know if there were a crowd in Brockton buying drugs at 2 in the morning on the street, or if, I mean, I didn't see any evidence.
Well,
from the brief.
there was at least 3 people there, because defense introduced a witness who said that he was also there.
With Jones and the victim?
Yeah, Willie Dukes was his name.
Is that a crowd, shooting into a crowd?
Well, I mean, I guess it didn't come up as whether or not there was a crowd. There was just a mention of a crowd.
No, well, that makes a difference, it seems to me, because some of your argument is that shooting into a crowd, you don't have the intent. But I don't see that there was a shooting into a crowd.
Well, I mean, I guess there was at least 3 people, and there was no more evidence of how big a crowd there was. But there was mention in these statements of a crowd, but there was never anything at trial saying there was this number of people there. And it did happen at 3 o'clock in the morning, but there was also evidence that this was an area of drug transactions and many shootings. So even at 3 o'clock in the morning, it was apparently a busy area with people hanging out.
Well, you also, no, I'm sorry, I take that back. I don't have another question.
Well, first off, we contend that Mr. Aylward's statement shouldn't have been admitted. Heidi Eaton, Mr. Aylward's girlfriend at the time, testified that Mr. Aylward said that they had gone to Brockton, that there was a scuffle. They went back, and Mr. Braley shot to scare these men. The trial
And he said that, and that was said, according to the witness who testified, that the co-defendant, what's his name, Mr.
Aylward?
Aylward,
Right.
said in the presence of the defendant what they had done. And and Mr. Braley, your client, didn't say, no, I didn't do that. What are you talking about? Isn't that an adoptive admission?
Well, that's what the trial judge found. However, Ms. Eaton never testified that Mr. Braley did not say anything. All she testified to was, I don't think he said anything.
And I would remember if he did, or something like
Yeah.
that.
And then on cross-examination, she confirmed that she didn't remember.
No, but she on cross-examination, my memory of the briefs was that she said that if he had said something, I would have remembered it.
I think if she said anything, I would remember. So it was not as definite as if he said something, I would remember. It was, I think I would have remembered. And then on cross-examination, she confirmed that she actually didn't remember.
Wasn't this for the jury to decide?
Well, as this court said in the Babbitt case, this evidence must be admitted with caution. And it has to be apparent that he heard and understood.
Wasn't there evidence anyway that the joint venture was still ongoing? Because even after that statement, they went and got a gun and they went back out to Brockton in a car?
Well, that would be the second point that the trial judge found, that it was also admissible as statements of a joint venture. But we contend that in order it to be admitted, there has to be other evidence beyond the statement that a joint venture occurred.
But there was other evidence.
There was cover-up evidence.
There was the evidence that they...
They painted the truck?
They
They
disposed
disposed of the gun?
Well, I mean, the truck is also a separate point, but without this statement, all we have is that they went to Brockton at some point, and both witnesses, Heidi Eaton and Victoria Braley, testified that they returned back to their home by 2 o'clock at the latest, where this incident, according to witnesses at the scene, didn't happen until 3 o'clock. So all we know is that they drove to Brockton in a truck and that they returned, and then
With a dog
With-
that's the same color as the Jones said that the dog was.
well, they had 2 dogs, and the witness said there was only one.
Only saw one.
And a police officer testified that at the time of the incident, they stopped 2 other trucks, including one that had a dog and a gun in it, right after the incident. And also that this was an area where there were a lot of shootings. And even the jury asked the question, can we have the police log for that night to tell us what shootings there were in the area? So even the jury was questioning, after all the evidence, whether or not these guys actually did it, because they felt that this was such a high crime area where there was a lot of shootings. So we contend that they weren't admissible as statements as a joint venture, because without those statements, all we have is they went to Brockton, they came back before the time of the shooting.
I recall one other series of statements. Didn't the defendant keep saying he didn't believe he had hit anyone?
He said that he couldn't believe he shot anyone. And the Commonwealth tries to make that into an admission that he actually shot someone. But what he's actually saying is, I can't believe I shot anyone. He doesn't think he shot anyone.
Well, why would he say it?
Yeah, why would he say
At
that
that
if
time,
he
he hadn't
hadn't?
been charged by the police, so
Well,
there's
because
nobody saying that he did unless it's he saying it.
subsequently there was a meeting between the 4, and they found out that there was this shooting that night in Brockton when they were. And, I mean, for whatever reason, they were worried that they were going to be implicated. So they decided they weren't going to talk about it anymore. And Mr. Braley said, I can't believe I shot anybody.
But
And-
at best, isn't it just, isn't the implication that he missed? Or he wasn't intending to shoot at somebody, but he wasn't intending to hit anybody. He was intending to shoot, but not to hit.
Well, I contend that I don't see, he's not saying I can't believe I hit anyone. He's saying I can't believe I shot anyone.
What does it mean? I mean, if you
Meaning,
didn't,
I can't believe, I didn't do it. I can't,
why
I
don't you
can't
say
believe I did
what-
it.
it seems it's an odd way to say you didn't do it.
Well, it's at least not a way to say I did do it.
Well, isn't that a jury question?
Um,
As to what it means? Because you could certainly infer that it's an admission that he shot.
Isn't the clear inference, I pointed a gun out of the window, I pulled the trigger, but I can't believe I shot anyone, hit anyone.
Well, I don't believe it is. I mean, I
Okay.
believe it's.
Well, is it a permissible inference? That's the important thing, because if it's a permissible inference, then the jury can surely have found that
I mean,
way.
I think just based on the words, it's not. It's, I can't believe I shot anyone. He's not saying it was an accident I shot someone. It was, I can't believe I shot someone.
I don't think you're persuading anyone on this point.
Well, I'd like to move on to another evidentiary report.
How did you get onto me?
What's that?
How did you get onto me?
Well, I mean, again, that's the same type of statement.
Isn't that a voluntary statement that he made? I mean, just a sort of a spontaneous statement.
Well,
The police weren't questioning him at that point.
well, that's what the trial judge found that it was.
Well, but the evidence, what were they questioning about? The evidence, as I recall, was that, and again, I haven't read the transcript yet, was that they were just making small talk because they had to pass the time until they got on the plane.
Well, I mean, police testified that they were talking to him because they wanted to keep him calm to take him on the plane. But prior to that time, the trial judge found that he invoked his right to counsel. So we contend that,
Well, it isn't in fact what happened if the police said, do you have a lawyer? He didn't say, I don't want to say anything to you because I want to speak to my lawyer. In this case, it was the state trooper saying, do you have a lawyer? And he said, I expect one to be there when I get there.
right,
Correct?
and the judge,
And I thought that statement, maybe I'm wrong, but I thought that statement about counsel was after the defendant had made the incriminating statement to the state trooper.
no, I
it was
believe it was
before.
before.
And
yeah.
I'm not going to quibble with you that we can deal with that as an invocation of the right to have counsel. But I thought, I mean, I looked at least that piece of the transcript that was in either your or the Commonwealth's brief that seemed to say that there was no discussion at all about the crime, the circumstances. It was all about family and, you know, whatever it was. I mean, it was small talk, correct?
Well, we contend that after he invoked his right to counsel, that they should have stopped all this small talk. And if they were,
But the
When
right
did
to
he-
counsel
when did he
means
invoke-
questioning. It doesn't mean you can't have small talk. I mean, how are you feeling? How's your family? It just means that you can't talk about the crime.
well, we contend that they kept up this conversation at the airport to make him feel comfortable, and then he blurted out this statement.
Mr. Baylor, you would have, I think, a perfectly legitimate point if, for example, somebody was at a police station or indeed in their home. I think that one of the questions here is, this was a long plane ride back from Florida. They had, you know, presumably, I mean, if you have had any recent experience, as I have, getting into any place, you sit around for a long time. He was not handcuffed. He was not handcuffed. And that may have been a choice, you know, so that there was, I mean, that one, so sort of keeping him calm is not just because they're being nice to him. I mean, they're trying to maintain a situation, and they, you know, as opposed to sitting there in stony silence and saying nothing.
Well, the police could have certainly talked to him to keep him calm, but then
that's what they did.
Well, if they did that, then the statements Mr. Braley's statements in response just shouldn't have been admissible. I mean, maybe
It wasn't a statement in response. It was a statement initiated by him. It wasn't in response to anything, as far as the evidence indicates.
we contend that it was in response to them talking to him and getting this general comfort level so that he would ultimately talk about the crime. They
Are
asked
you
about his
are you
family,
saying
why
that
he
they
was
shouldn't have engaged in any?
No, he just
interaction
said they
with him?
could.
I'm saying for the purposes of admissibility, anything that would have been any response should not have been allowed in.
So no conversation?
Well, they could, I mean, if they had some other reason for the conversation, they could have done it, but I don't think that a resulting statement should have been allowed in.
Is that a focus of the motion to suppress, that the police had actually engaged him in small talk to try to soften him up?
It was one of the
Yes.
focuses.
Okay.
But even beyond that, the trooper's response to him should not have been allowed in. His response was, he said, "How did you get on to me?" And the trooper said, "Your partner is not as good at keeping quiet as you are." And we contend that even if his statement, which doesn't necessarily mean anything, "How did you get on to me?" It could have been, you know, "I'm in Florida, why did you come and get me?" You know, it had nothing to do with anything. But that response goes to this whole joint venture and really goes to the heart of the case. And it's not based on anything beyond an opinion of the officer. And we contend that even if they admitted that statement, it should have stopped there. It shouldn't have been.
Then we have to, assuming you're correct about that, and I certainly have the same question you do, how is that relevant and how is that admissible? The question is, was it prejudicial in some fashion? There's already plenty of evidence of a joint venture. The only thing that confirms is that there was a joint venture, or that he had a partner, but that was the whole case.
I mean, I don't believe there was plenty of evidence of a joint venture. I mean,
They traveled together to Brockton with guns, they shot someone, or they shot something. They came back, they had conversations, they decided, I mean, there was a whole bunch of stuff that they did together in connection with traveling to Brockton with the gun and the dog, returning, traveling back again, returning, and then taking steps to cover up the crime. I mean,
that adds to this whole series of evidentiary rulings that we contend were wrong. I mean, one of the things that I haven't reached yet is that Mr. Aylward's actions after the crime, we contend, also should not have been admitted.
Can I just go back to the trooper's response to the question, "How did you get on to me?" and the trooper's response on the airplane? Did the prosecutor argue in closing that the defendant's failure to respond to that response was an adoptive admission?
I mean, could you repeat that?
Yeah, the trooper responded
Yes.
about, your partner is a lot better at you're a lot better at keeping quiet than your partner is. Did the prosecutor argue that the defendant's failure to talk any further about that or to deny anything about it?
Yes.
Did he argue in closing that was an adaptive
Yes,
admission?
and that was a big part of my, one of the issues in my argument. We say that the closing argument, the prosecutor was commenting on Mr. Braley's silence.
But he didn't comment on what the trooper said. Did he? I think Justice Sweeney's question was, did he comment on the trooper's answer?
As an adoptive admission?
I don't believe he did. I mean, I believe he talked about how did you get on to me as an admission.
He focused on the question as opposed to...
Right.
Mr. Baylor, the law is clear in a sense that you have to have an you have to find that what the police are doing is reasonably likely to elicit an incriminating response. And the Commonwealth, has pointed to a couple of United States Supreme Court cases where, in fact, the so-called banter was deemed to have been designed to elicit a response. Have you looked to see whether there are any cases where there was this kind of extensive banter in the course of which, assuming that we conclude that he had invoked his right to counsel, where something is said which has been upheld? And it seemed to me, again, without going back and looking at all of the cases, that there are lots and lots and lots of cases where there's been an invocation of a right to counsel and then the defendant initiates conversation.
Right.
Right? So he says, the classic one is that the police officer is sitting in the questioning room at the police station saying absolutely nothing. And the silence goes on for a long period of time, and then the defendant says something. No initiation.
Right. Well, I didn't come across a case where there was a long series of banter where it was found not to be admissible, but we contend under the general principles that, I mean, he clearly he invoked his right to counsel, and that at that point they were still asking him, how's your family, how did you get on, I mean, why were you in Florida, what were you doing, I mean, questions that were clearly would have given them an incriminating response. Did you run away to Florida, what were you doing there, who were you living with? I mean, they didn't stop questioning. So it wasn't just the length of the banter, it was also that it continued in questioning that could have led to possible...
well, the Commonwealth's position is that this wasn't an invocation of a right to counsel.
Well
aren't the cases fairly clear that you have to make an unequivocal assertion of your right to counsel? And
the trial
if we got to that point.
The trial judge found that it was an invocation of a right to counsel. And with all due respect, it didn't come up as an issue during this hearing because the judge apparently found that it was. So I guess defense counsel had no reason to go further into exploring whether it was an invocation of a right to counsel because the trial judge found it and based her decision on that. I see that my time is running short, and I would just like to mention just a couple things very briefly, that Mr. Ailboard's actions after the offense, we contend, were inadmissible because any joint venture that existed ended.
How so? When your client was the one who said, we better keep quiet about this, 10 days later, apparently, he said, he said afterwards, we've got to keep quiet about this and never to talk about it again.
Well, because the following day, there was no evidence that Mr. Braley was involved. Mr. Ailboard and Hyde Eaton saw the Brockton Enterprise newspaper that had a story in it about a shooting in a parking lot. As a result, Mr. Ailboard repainted his truck, put a cap on it, and left out of state. But Mr. Braley stayed in the house. We contend, and it had nothing to do with Mr. Ailboard's actions following the incident. We contend this is very close to the Pringle case where two co-defendants, one gave a false name and one gave a correct name. And the court said that that wasn't admissible. Again, giving a false name wasn't admissible because the joint venture had ended. So even though that when Mr. Aylboy came back from Maine, they had this meeting, it didn't mean that it didn't end and then maybe start up again, but that it ended the next day because Mr. Braley had nothing to do with the paper, Mr. Aylboy's actions.
How long was it before the defendant moved to Florida? After the shooting?
I don't believe that was in the record, but it was months and months later that he left the house where he was living in Whitman, and it was because he was evicted. I think the evidence was that he moved to Western Massachusetts, and then I don't recall any evidence about when he moved to Florida. But he stayed in the house. It wasn't like he left shortly after or anything like that.
Mr. Baylor, I want to return to your point that the judge found that there had been an invocation of a right to counsel. She makes oral findings, and so taking that into account, when it turns to that point, she's making quite specific findings. She finds and credits the trooper's testimony that he was advised of the Miranda rights, and the defendant in response said that he understood his rights. And then she says, later the defendant also mentioned that he expected that an attorney would be appointed or retained to represent him upon his return to Massachusetts. And then she continues, to the extent that he asserted any further rights, it's not clear to me what that meant. Is that what you are relying on to say that she found that there was an invocation?
Yes, because I think when she says it's not clear to her, she's talking about any other rights, not the right to counsel. But I think she's saying that it was an invocation of the right to counsel.
Okay. Thank you, Mr. Baylor.
Thank you.
Ms. Lee?
Good morning. May it please the Court, Mary Lee for the Commonwealth.
Could
Plymouth
you just
District.
clarify that, Ms. Lee? Is that
Sure.
have you listened to the transcript?
Read the transcript, yes.
No. Have you listened to the recording?
No.
It's not clear to me what Judge Giles is doing there. Is she saying, I don't know whether he invoked his right to counsel, but I don't, and then the rest of the thing, she's absolutely clear and unequivocal that that there was banter and this was not designed to elicit. I mean, that's the clear import of her ruling, correct?
My understanding of her ruling was that she basically wasn't sure what the defendant meant when he said that a lawyer would.
Doesn't that prove the point that
It
it's
does.
that it's not an unequivocal assertion of
Exactly.
his right
The
to counsel?
defendant has to clearly articulate both his right to silence and his right to counsel. And so based on her factual finding that she doesn't know what it meant, legally that means he didn't invoke his rights properly. And then she went on to say, but the officer testified that he did invoke his rights. And so she treated it as if the defendant had invoked his rights. But when you look at the officer's testimony.
Right. No, I have looked at the officer's testimony.
In the motion to suppress, the officer said that he invoked his rights after the officer replied, your partner was not as good.
I haven't
Right.
looked at that testimony.
And so to the extent that she would be relying on the officer's testimony of an invocation of rights, that would be clearly erroneous for that finding.
So you're saying
she
that,
jumped to-
that the statement was before.
Oh, no, I'll go through the chronology of it. They get in the car, they Mirandize him. It's the state trooper who Mirandizes him from the front seat. A Brockton police detective is in the back seat with the defendant.
And this is in Florida 11 years afterwards.
Yes, and they're in the car before they head to the airport, and then the Brockton police officer asks the defendant, do you have an attorney? And the defendant makes the statement that the judge finds that is not clear what that means. And they don't talk anymore in the car. They go to the airport. They get ready for their flight. They have to wait around a couple of hours. They can't put handcuffs on him because of FAA rules in that airport, evidently, that he's not permitted to be in handcuffs. So they engage in some sort of banter, light banter is how the judge characterized it, to keep him calm, keep it all polite. Sometimes the officers are talking to each other. Sometimes they're talking to him. The things they are talking about is work, what's it like living in Florida, how's the weather. that kind of stuff. The defendant asks about his wife and daughter, who are still back in Massachusetts. And then the Brockton police officer gets up to go get something to eat. And that's when the defendant says to the state trooper, how'd you get on to me? And the state trooper makes his statement, your partner wasn't as good at keeping quiet as you were. And at that point, according to the officer's testimony, the defendant invoked his rights. So that's the scenario and the fact pattern.
How did you get on to me without the follow-up response?
We'll deal with the follow-up in a
I mean,
minute.
it's, I think the Commonwealth makes the point that he wasn't saying you've got the wrong person. I mean,
It's
clearly
the
whether
closing
that could
argument
come into...
issue. There's two issues there.
Clearly whether that could come in, but at least a jury could infer that how did, why me sort of thing. But
I think the statement in, the Commonwealth's position is that the statement, as the judge found, is clearly admissible because it's a spontaneous statement by the defendant, and this light banter is nowhere near the functional equivalent of custodial interrogation like you would find in the Christian burial case, or I hope the kids don't find the gun case,
it also seems very, it didn't flow from...
It's a complete opposite of what they're talking about. It's not the kind of thing that they're trying to, butter him up and lead him up and say, how did you do it? It doesn't go. They didn't ask any questions about the murder. They didn't talk about the murder at all with him. They intended not to talk to him about it. Once they got there, they gave him his rights, and their sole purpose was, let's get him back to Massachusetts, and that's what the trooper testified to.
So how is the trooper's response admissible?
Okay, so I think the statement, how'd you get on to me, can be seen as an admission. That's my point. The trooper's response, it doesn't appear to be admissible. It doesn't show how, the conversation cut off. The jury were not told that he invoked his rights after that statement. There's no evidence of what happened after that statement. And my recollection of the prosecutor's closing argument is that he may have commented on your partner, wasn't as good. He may have said that statement but didn't say anything about the defendant's lack of response after that. Admissible, I would suggest, the Commonwealth is arguing that it's cumulative and therefore not a substantial likelihood of miscarriage of justice in this
Was there an
case.
objection to it?
I believe there's no objection to that.
Okay, as you understand, that'll make a difference.
Obviously, I'm going to qualify what I'm saying. Obviously, the defendant brought the motion to suppress, and because it raises a constitutional issue under Martin, it's preserved. And to the extent that that's the officer's response,
It's preserved.
is part of it.
This is
So I would
preserved
suggest I'm going to backtrack from that.
Okay.
It's prejudicial error because of Martin. There was not an objection at trial, but it was
Okay.
preserved through the motion to suppress as a constitutional error. And thank you for correcting me on that. The point is, we've got a preserved error here about the officer's statement bag, and there's really no reason why that statement should go in except at best to show how the conversation ended. The Commonwealth suggests to the court that it is cumulative, and under Mendez, it does not create a prejudicial error. Because it is cumulative, it doesn't really add anything to it. The evidence shows that the Commonwealth's theory of the case, and there's lots of evidence of the joint venture, and that Alibord was the one sitting there talking with Heidi during the whole conversation.
So
This is not...
Is it the prejudicial error standard we use or the harmless beyond a reasonable doubt standard we use? Or does it matter when it's cumulative in this section?
I think it doesn't matter in this case because it's cumulative, and because the defendants are arguing that this is essentially an expert testimony that he's guilty, like you would see in Woods. And in the Woods case, they found that it was expert testimony. It was a drug deal kind of case, expert testimony that the person was a drug dealer. Right. And even though that expert testimony from the officer came in, it did not require reversal in the Woods case. So I would suggest even on the standard the defendant is raising, this one statement, it doesn't add anything to the Commonwealth's case. It's purely cumulative.
All right. Well, then let's move to the closing argument in which the
the
defendant's statement, how did you get on to me, is then used by the prosecutor, in essence suggesting if he wasn't, you can argue that in essence it's suggesting if he wasn't guilty, he would have said something different. Like, what are you looking for me for? Why'd you come to Florida or something?
The essence of a Doyle error is that the defendant's silence is used against him. Doyle versus Ohio. The defendant's silence is used against him to infer his guilt, that an innocent person would say, I didn't do it. And I understand why this would be raised based on the prosecutor's comment, where, if you look at it in a vacuum, he does say, the defendant isn't saying, why are you arresting me? Why are you bringing me back to Massachusetts? I didn't kill anybody. He actually says that in his closing argument. But when he's making these comments, he's making them to say he knows why he's being arrested. We know that not from what he didn't say, but from the statement he did say. How did you get onto me? That statement, how did you get onto me, after an 11-year span and after the extensive concealment and the agreement of the parties, we're never going to discuss this again, makes so much more sense. It provides that inference to the jury. How did you get onto me means, how did you find me after all these years?
Well, that argument
How did the concealment fail?
That argument can surely be made. It's very easy to make without saying he didn't say
Sure.
he didn't kill him. He didn't say.
Yes, and
Isn't it
so,
the sort of statement that it would have been preferable, it would be better left unsaid, as we've
Oh,
said
yes.
many times, but it's really embroidery on the defendant's statement and
Exactly,
an
and I-
attempt to give weight to what the defendant had said.
I
weight and
compare it
meaning.
to the Thompson case. The Thompson case, the defendant, his wife had been murdered, and when he's being questioned by police, he doesn't say, are my wife and daughter all right? And the prosecution argued he doesn't ask that because he knows that the wife's not all right and the daughter is all right. And so that's why he doesn't ask that question. Thompson, you might say, can be distinguished from this case because it's a lengthier statement and this is just a one-liner. But I suggest it's the same kind of argument. And we actually see a similar argument in a recent case, Commonwealth versus Nolan, which just came out, 448 Mass 207. In note 13 of that case, that's a 2007 case.
Just remind me of the facts.
The Nolan case is a man who, it was a circumstantial case of a man who murdered a person in a boathouse on the Cape.
I'm with you. Okay.
And yes, they were saying, he didn't need to ask how was the victim killed when his friend called him. He's in jail, and it's a recorded phone call in the jail. He didn't need to ask, how did he get killed, because he knew. And so you see a similar argument like that.
Huge difference. In the Nolan case, that was a tape-recorded conversation between Nolan and a third party, not a police officer.
That's true, and
Here
which
we
is
have
why
a
Thompson's
conversation
important.
with a police officer.
Right. So let's jump to, okay, let's say you find that this is error. Then we go through the analysis, the Doyle analysis, and say, does this require reversal? Does this statement, which I've quoted in my brief by the prosecutor, require reversal? And so we look at Mahdi and Broom, and in those cases we say, look at the relationship between the evidence and the defense. In this case, the argument is that the statement was an admission, and he's using that to, he's using it like Thompson. And in addition, while it was the Commonwealth who introduced the issue at trial, the weight and quantum of the evidence was strong. There was just that one reference in the closing argument, and most importantly, there was an objection in this case, and so the judge gave a curative instruction. The defendant suggests to you that it's just
During closing argument?
right after closing argument.
I mean, yeah, okay.
The argument's completed, defense counsel raises the objection, and they talk about it for a minute, and the judge gives an immediate curative instruction. The defendant says it's a general instruction. It's not. It specifies. The prosecutor said in his closing argument that the defendant didn't say stuff. He's not required to say anything. He has a Fifth Amendment right. And I quote that in note 4 of my brief as well, at pages 38 to 39. In addition to that curative instruction, the judge did give the instruction about the defendant doesn't have to prove anything, doesn't have to say anything, can say to the Commonwealth, you prove it all against me. That's what makes this case different from Haas. That's what puts this case in line with that it should not be reversed on this ground. Those words should not have been said. It's better not to say those kinds of things. You can make that Thompson argument and that Nolan argument to draw the inference of what the defendant's statement means without saying he didn't say I didn't kill anybody. But we have a strong curative instruction right after the closing argument that specifically references that portion of the argument. And so I would suggest that cures it in this case. Unless there are further questions, I'll move on to the next issue.
It's not directly relevant to this point. In this case, did the trial judge give the jury her instructions?
Written instructions?
Yes.
I believe I know this judge usually does.
Yeah. Okay.
So I believe she did, but I can't remember specifically.
All right,
and
thank
if
you.
she did, the curative instruction would not be in
No, I
there.
didn't think so. Okay.
I can't imagine any way it would get in there. Moving on, I would like to address...
Well, she might, it'll be interesting. She might have. Are those in evidence? I think they typically are marked for, I'll check.
I don't think that they're in either record appendix, so,
Okay.
I don't know the answer to that question, though. I assume if they gave written instructions, they become part of the record, though.
Yeah.
So unless there are any other questions on that issue, I would like to briefly address the other closing argument issues. The defendant says that the prosecutor made several comments that were not based on the evidence, and I find only one of those to be supported, in that he said Heidi, that's the Alabord's ex-girlfriend, Heidi testified that she was sure that they left in a blue pickup truck with the two dogs, and in fact, Heidi testified she was sure they left in Alabord's pickup truck with the two dogs, and that one of the dogs was a medium-sized tan dog. She was sure of all that, but she wasn't sure of the color. In fact, she said, I think it was dark colored. And so that comment was wrong. The prosecutor premised his closing argument. It's a misstep in the argument, but he premised his argument with, if the facts don't match up to your memory controls, that's a point that was reinforced by the judge in her instructions. This is a misstep, and it's, the blue pickup truck. Yeah, there was evidence from Jones that the truck that pulled up to them was blue, but Duke said the truck was white. And then Heidi actually testified that it was dark. So, the pickup truck stuff onto the color, he was wrong about it, but it's just a misstep, and I would suggest it doesn't cause reversal, given that he said, hey, you remember the facts better than me, and the judge reinforced that point.
You said something in your brief that no such robbery of the defendant had occurred,
right,
because of Jones's testimony. Mm-hmm. But Jones testified that he was with the victim only for about a minute and a half.
Oh, I believe that's not accurate. I believe he was with him for at least. He was there for about 15 to 30 minutes. You'll find that on transcript 2, pages 33 to 35.
Okay, maybe then I misread the brief. I thought that's what the brief said. Okay.
He was there for about 15 to 30 minutes,
yeah,
and
but
that they talked.
But it still doesn't mean that the robbery hadn't occurred earlier. I don't think it's.
Their conversation lasted a minute, but according to Alabord's statement to Heidi, in the presence of the defendant, they pulled up to a group of men, and that actually, to answer your question earlier, the crowd and the group stuff comes from Alabord's statement to Heidi.
Oh, okay.
He said they pulled up to a group of men to ask for directions, and that one of them punched him and robbed him. So he and
they went around the block.
The defendant drove around the corner. He handed the .22 caliber rifle to the defendant. They drove back around and to scare the men, and the defendant, Braley, shot into the group, or into the crowd. So he described it as a group of men and a crowd of men. Jones testified that there were only two people on the side of the street, him and the victim, and that when the gun came out, they went running. And
well, he testified to more than that. He testified they actually followed him, didn't they? I mean,
they were in a parking. They were next to the parking lot.
And then they drove over.
No, they were pulling up very slowly,
right,
and the passenger side of the truck was on their side of the street. Jones got a real bad feeling about it right away and started walking away before the truck got up to them. And one of them said something. The passenger, he thought, said something to Mr. Sheeran. And then he saw the butt end of the rifle coming out of the window, and that's when he started running, and Mr. Sheeran started running. Mr. Sheeran was then shot in the back and fell onto the ground in the parking lot. Mr. Jones dived behind a car. So the truck was on the side of the road slowly, but the shots were coming right at them.
But my point,
at them, but not following them.
Is that after they shot the victim,
the shots kept coming.
Jones, is moving, and they are following him as best they can and shooting again, because he said he was trying to get into the pharmacy or something.
He was trying to get into a bakery. The bakery was open and baking bread, but he didn't say that they were following him. He said that he ran around a car, and the window of the car got shot out, and then he tried to run to the bakery, slipped in some oil, and the shot came right above his head and hit the wall behind him. So the shots were being aimed at the people, according to Mr. Jones, but not that the truck was following them into the parking lot, because the truck continued down the street. Okay. And when Mr. Jones then got up, he had to run in the same direction as the truck down the street to the Christie's to use the phone, because the bakery wouldn't let him in. The door was locked. I did want to address the involuntary manslaughter argument just briefly. I would suggest to the court that the cases cited by the defendant in his brief are just that involuntary manslaughter instructions are given in certain circumstances, not that they're required. And in fact, Gibson, that he cites, he cites it for the wrong premise. In the footnote in Gibson, it says that the instruction wasn't required in that case. The two cases that I found that talk about when you're not shooting at people and you get an involuntary manslaughter instruction, they're really limited to their facts. Kenny, he was actually being attacked by a group of people, and he tried to shoot into the ceiling just because he thought he was going to get killed. He had a heart condition. And in Ferrara, there was a witness who said he wasn't pointing the gun at the victim. We don't have anything like that here. We have 4 to 5 shots. 1 hit the victim, 2 almost hit Jones, and who knows where the other shots get. That's pretty accurate shooting on the side of the road. And in addition to that, the co-venturer's story to Heidi is that the defendant shot into the crowd, not away from the crowd, not into the air, nothing like that. And mere purpose to scare under Mack does not get you an involuntary manslaughter instruction. And why? And you see the answer in Simpson. The reason is someone's going to get killed when you start shooting at people to scare them. And the risk is too great, and that's why you don't get an involuntary manslaughter instruction. In terms of accident, that he's claiming there's some accident that should have been given. Childs and Millian both stand for the proposition that intentionally shooting at people does not support an instruction for accident. So I would suggest to the court that this instruction was properly not requested by the defendant. There's nothing in the record to say that this was accidental or an involuntary manslaughter, and the judge was correct in not giving it. I see that my time is running out, so unless there are questions on any of the other issues, which I'm happy to answer, I would ask this court to affirm the conviction of the defendant for murder in the first degree.
Thank you.
Thank you, Ms.
Thank you.
Lee.